or particularly, we'll talk about a lot of things in terms of things, components, elements, um, per se are not patentable. Few of the favorite refute which is provided before the Indian Patent Office while overcoming the objection. So, one of the favorite objections is, particularly in the mechanical domain, would be the arrangement of the elements, or perhaps if I talk about software, so arrangement of the modules and the submodules is nothing new. It is mere arrangement. And what we are going to do is we'll talk a little bit more. Taking some examples from the standpoint view of how we overcome the section 3 of the Indian patent law. In most of the inventions, until unless the invention is really drafted well, um, there is some sub rule of section 3 which is always invoked by the patent examiner, and it's a good thing. I mean, um, it's always good that the patent examiner is objecting to the invention in question. First of all, defining it as an invention itself has a lot of steps before we can say this is an invention and not an idea. Idea per se is not patentable. So let's try and deep dive into this. Um, I'll take a problem statement which we just overcome a few days back. Um, I'm particularly looking at the section 3. Okay, so a lot of these subsections of section uh, 3 of the Indian Patent Act, that is the Bear Act 1970. One of the subsection is 3F, which talks about a mere arrangement or rearrangement of known devices. So just arranging the devices, particularly we can talk about in terms of the modules, not modules per se. Let's talk in terms of elements and components for the sake of simplicity. When these are utilized, so this is one of the objections, and if the invention is pertaining to it's one of the favorite objections in terms of mechanical, electromechanical, even software mechanical innovations, which is a hybrid of both. And then one of the other ones is section 3K, that is computer programs and the like. And 3D is for evergreening, particularly in the pharma sector. um, Now let's try and understand it in terms of, um, say for example, it's arrangement of known parts. If we are talking about a cycle or bicycle, tricycle, so a lot of these apparatus are being developed from the standpoint view of fitness. So let's take the sector of fitness here and try and understand the innovation in a manner whereby we need to overcome the objection where the examiner is stating that it is mere arrangement of known parts in terms of a wheel, a pulley, a belt, spoke, and the like. Um, Now, what happens here is, um, there has to be, or the emphasis while drafting a patent application, whether in India or globally, is technical effect. Now, when we are trying to explain the technical effect, it is always good to give loads of examples. When I say examples, it is actually pointing out to embodiments. One of our favorite words when we are drafting patent application is to use the word embodiment, and it has to have a technical effect. Second is when these elements and components are utilized as such, um, the non-obviousness of the interaction as to how, say for example, just a very hypothetical example, we have four wheels to execute something, and the positioning of the wheels is causing an effect. So this is non-obvious of the interaction, because how the four wheels are interacting, at what angle, and what it is supposed to do in terms of the functionality. It's a lot of emphasis while writing a detailed description of an invention is the functionality aspect of the innovation in question. So one has to put a lot of emphasis, a lot of emphasis. Most of the applications which are being filed right now, because most of the folks are just using these GPTs and just they think they have drafted the best of the application. That's not the case, because still there's a lot of hallucinated data which, as a innovator, you're not able to see because you are just seeing the basic landscape in terms of the components, the elements. That's it. You need to understand, or I rather say, you have to work with an expert and draft it in a format where it is the best of the both worlds. When I say it's the best of the both worlds, it means that the invention has been replicated on paper in the best possible manner, which is giving a lot of weightage in terms of, if you have a patent certificate, it should be of value. So that is something you need to see. Then the parts or the components in which it is working together should not be a routine design by choice. Then we have dismantling. Now, what has happened is a lot of innovations which are not filed in India, but maybe filed somewhere else. A lot of folks are, what they're doing is they get the device or the innovation, dismantling the same, and doing the indigenous version in their home country, and then filing for industrial design patents and the like. Now, we have been getting a lot of inquiries regarding the same. So, the first step here is for these companies whose product is being copied is to give a legal caution notice. Um, Now, the point here is to understand that when you are writing a technical paper, so this is not a technical paper, writing a patent for innovation, invention, it's very different from a writing paper for technical aspect, because technical aspect is like a storyline which has different embodiments in terms of the body part, the background, and the like. But from the pattern point of view, it is very important, particularly from the mechanical standpoint, that the blueprint should be good enough so that, as someone who is representing the client before any of the patent offices, should be in a position to alter the data if required in terms of getting the patent granted. And for that, the technical impact of the write up has to suffice the purpose, because you cannot add a new matter or a new data set at a later point. Um, Now, let's try and understand this problem statement of Section 3F of the Indian Patent Act. Okay, you need to quantify in terms of the components and the elements which have been disclosed in the detailed description of the patent application, and that data should provide the technical effect in terms of performance. So tabular format data in terms of different experiments is always good, particularly from the standpoint view of an invention which is hardware based. And even if you're talking about composition, it's always good to provide that data set. Then, okay, so I'll just look into the language. So, particularly, the standpoint view is when you have the elements, the components, even if it is known, but used in a similar fashion or in a particular fashion, it is important to understand that that itself can be utilized to overcome the objection only when the experimental data is there in the application, and it should be in a tabular format. The more the data, the more would be, say, for example, there are a couple of elements. We talked about taking an example of bicycle or a tricycle from a fitness point of view, and certain elements which are already known in the art are utilized or positioned in a certain way at some angle. So the ratio format or any kind of mathematical equation which can be utilized to give that data set saying that, hey, these four are better when they work in synchronicity. So that is how you overcome section 3F of the Indian Patent Act. And another thing is, nowadays the inventors are giving affidavits, but that is only an additional document. That doesn't mean that the application would be accepted. What is more important here is as to how fast you are able to launch your product. You don't have to um, wait till the time you have a patent certificate. It is more from the standpoint view of understanding the trade secret aspect and what to disclose, and still able to disclose that much which is enough for a application to go through the stage of the patenting. And then of course we understand that this is one way of the way the capitalistic world works, particularly from the standpoint view of mechanical innovations. So thank you for watching this out. We will restart with another application in a while. So I just wanted to talk about Section 3F right now of the Indian Patent Law 1970.